Hello and welcome. Today myself, Trupti Upadhyay, will take you to another series, another lecture, another topic on the company law. You already know that I have already uploaded around 6 lectures of company law, right? So if you have missed any of the lectures, any of the topics, you can go through the topics beforehand, and then we can start. Today's topic is a new topic. Basically, we are having a series of lecture on company law, and this company law we are covering the entire syllabus of University of Calcutta semester 2. So basically, the target audience of this lecture are the students of University of Calcutta, but I would say that this company law topic is so much diverse that any other university students can also view the lecture. This will be beneficial for them as well, and also this is always beneficial for the professionals who are supposed to give their examinations in this subject. Okay, so all the professional students as well as the students of other university apart from the Calcutta University can also view this lecture. And also, if please, I would request everyone that if you have missed the previous lectures, the lectures are available on the channel, so please kindly watch them. I have already uploaded the lecture on appointment of directors, removal and resignation of directors, duties of directors. So these are important topics, and obviously this would require these first you should view these topics, these videos, and then you should go through this video because everything is linked, right? And that's why. And for more concept clarity, I would request you that please try to share this lecture among your friends as much as possible, because I know that in this lockdown situation, we can communicate and we can obviously show a person that I care for you just by giving him or her the proper help which we can give. Okay, so let's start today's lecture. Before starting today's lecture, these are the few books. Not, I would say this is not the exclusive list. You can still have, you can add any more books which you can like to add it. But these are the few standard books which are available. So you can go through these books. These are available. This is the website where you can get the entire Companies Act ebook. So you just have to visit this website mca.gov.in, and from there you can access the ebook of Companies Act. Today's topic for our discussion is powers of the board. This is a very important topic, so I would request you to kindly see the entire video for concept clarity. Okay, the powers of the board are covered under various sections of Companies Act, and we shall go through all the sections one by one. First section and the most important section is section 179. Under section 179, the board of directors are authorized some powers, right? And these powers of the board comes from where? The powers of the boards come from the articles and the memorandum of the company. Powers of the board comes from the act as our Companies Act, and other regulations which internally the company makes. Okay? The board of directors shall not exercise any power or do any act or thing which is directed or required, whether under this act or by the memorandum or articles of the company, to be exercised or done by the company in the general meeting. So this means that in the general meeting, some powers are specifically given to the shareholders. Board of directors cannot act individually, I would say, without taking the consent of the members in the general meeting. So we will discuss about these powers as well. So if the act specifically says that this matter has to be first discussed in the general meeting and permission need to be taken from the shareholders first, then only the board can act upon it, then obviously the board will use this route. Otherwise, this would be the violation of this section. Okay, and the board of directors can be penalized individually and jointly for violation of this particular section. No regulation made by the company in general meeting shall invalidate any prior act of the board which would have been validated if that regulation have not been made. What does this mean? That if suppose today in the general meeting it was decided that MD will not do this act, a particular act, but previously there was no restriction, so MD has already done that act, so any prior act which was done by the MD will be valid. But this only means that retrospectively, in the general meeting, the shareholders cannot invalidate any of the act which was previously done by the board. Okay. Subsection 3 is of utmost importance, so I would request you all to please kindly read the words and try to understand the meaning of it. I'll try my best to make you understand, because the entire, I would say, the main thrust of section 179 is being given to this section, this subsection. Subsection 3 lists down the powers of the board. Okay, and that is our topic. The board of directors of the company shall exercise the following powers on behalf of the company by making a resolution in the board meeting. So we are required to pass a board resolution to in order to exercise these powers. We means the board of directors. First power is to make calls on shareholders. We already know that if a company is making any public issue or a private issue, whatever, private placement, then obviously the call money comes into the picture. On application, some amount is taken, on allotment, some amount is taken, on various events, on different events, the calls are made. So making a call on shareholders for the call money on the unpaid shares, we need to have a BR. Board can do it. Authorize the buyback of securities. We know that the company can own on their own. They can issue the shares, and they can also buy back their own shares. Regulations, the provisions are given specifically for buyback under section 68. To issue securities, including debentures, whether in or outside India. So if you want to company want to issue any securities, the board can do it through BR. D, E, F are the most important powers, and we'll discuss upon this in, I would say, at length. First one is the borrowing of money. If company wants some money, how to borrow it? There are various sources. So from different sources, different money can be borrowed, and borrowing of money, the powers are vested to the board. Investment of the funds of the company, granting of loan, giving of guarantee, providing of security in respect of loans. These are all the powers of the board which can be exercised through BR. To approve the financial statements and the board's report. Obviously, the financial year 1920 has already been completed. So all the companies are in the verge of approving these financial statements, preparing and approving, finalizing and approving. So approval first comes from the board, and then it will go to the shareholders in the general meeting. That is our AGM. To diversify the business of the company, if a company is suppose in the business of making, only the toiletries. Now the company also want to enter the market of making biscuits or any other market, suppose selling insurance, then obviously diversification is possible. It is possible, so this can be done through the board of directors by BR. Any approval of any amalgamation, merger, reconstruction scheme also is done by the board. To take over any company or acquiring a controlling or substantial interest in another company, then also the requirement of board approval is required. In any other matter, the three matters which are given under point K are any other matter which is specified by the Act and the respective rules. First one is, in order to make a political contribution, company can make a political contribution, but the board's approval is required. And in some cases, with this point, we will discuss at length in a particular subsection which is devoted for political contribution. So I'll come to this topic again. To appoint or remove KMPs. We know that are there, some key managerial personnel are there which are defined under section 203. So we'll take a separate lecture on this KMPs, because KMP is a separate topic. So stay tuned to this channel. We will be going through KMPs one by one, role, responsibility of everyone. But understand here just that the appointment and the removal of the KMPs will be done through the board only. So KMPs are, directors are appointed by the company, that is the shareholders, in the general meeting. But the KMPs are appointed by the board of directors in the board meeting. To appoint the internal auditors and the secretarial auditor. Here one thing is missing. You can guess. What about the statutory auditors? Who appoints the statutory auditors? This question should come in your mind. I would say here the internal auditors and secretarial auditors are appointed by the board of directors in the board meeting through board resolution. But the statutory auditor is one of the item of ordinary business of the general meeting. So the statutory auditors are appointed just like the directors by the shareholders. So this is a very important point. Kindly remember it. This can come as an MCQ question. Okay. Next. The board of directors can delegate also the few powers. Which are the powers? The powers which are given under clause D to F, which we have already discussed, the power to borrow money, power to make investments of the funds of the company, and also power to give loan, provide guarantee, provide security. So this for D to F, which we have discussed in the previous slide, this can be delegated by the entire board will not take the decision. A specific committee, managing committee can do it, where a managing director or a manager may be a head, or a principal officer of the company may be a head. In case of branch office, a branch office principal officer can given the responsibility, right? So board is of 10 people, committee can be of 4 people, 5 people, 6 people. As per the requirement, the board can make their own committees. Okay. Here one exception is there. The acceptance by the banking company in the ordinary course of its business. What is the ordinary course of business of a banking company? The banking company can, ordinary course of business of a banking company is what? Banking company's ordinary course of business is to take the deposit and deposit of money and from the public and repay that deposit on demand or otherwise. And of course, the withdrawal can be done by check, draft or otherwise, right? And this is the ordinary course of business of a banking company. So banking company, if it conducts the ordinary business, accepts deposit or gives loan in the ordinary business, then that this shall not be deemed to be the borrowings of the company. You know that bank is also a company, right? Banking company Axis Bank Limited is also a company registered under the Companies Act. So they also have to also comply with Companies Act 2013 and also the Banking Regulation Act 1949 and other rules and regulations given by the RBI. Here next thing is there, that what will be considered if these are few exceptions, that borrowing of money, this entire clause D speaks about the borrowing of money. So borrowing of money by a banking company from any other banking company. So if Axis Bank is taking loan from ICICI Bank, or loan is taken from the RBI by any commercial bank or State Bank of India or any other bank, this shall not be considered as a borrowing under clause D, which we have discussed. Next, any arrangement made by the company, our company is normal company, with its bankers for the borrowing of money by way of overdraft or cash credit will come inside the borrowing of money clause D. But what will not come? The actual day-to-day operation on overdraft, cash credit or other accounts by means of which the arrangement was actually made shall not be coming. So day-to-day transaction of your CC account or OD account shall not be considered, but the limit, actually the bank gives you the OD limit or the CC limit, the limit of entire limit will be considered as a borrowing, but the day-to-day transaction will not be taken into consideration. Other thing is there, nothing in this section shall be deemed to affect the right of the company. That means that the company in general meeting means that the shareholders can impose the restrictions or can impose certain conditions on the board of directors. That first you have to fulfill these conditions and then only the board can exercise these XYZ powers. Okay, which are listed under subsection 6. Subsection 3 for your correction. Fine. Next is the section number 180. Section 180 impose certain restrictions on the powers of the board, which we'll be discussing now. Under section 180, first subsection speaks about that these are the few powers, A, B, C clauses. These are the few powers which can only be exercised by the board only after taking the consent of the company by SR. So first you have to pass the SR, then only the board of directors can exercise these powers. Okay? What are these powers? First one, to sell, lease or otherwise dispose of the whole or substantially the whole of the undertaking of the company. And where the company is owning more than one undertaking, the whole or substantially the whole of any of its undertaking. Now, what is the meaning of the term undertaking? Undertaking means an undertaking is a undertaking in which the investment of the company is greater than 20% of its net worth. Net worth is 100 rupees, then more than 20 rupees company has invested in, suppose, another company. Company has invested in company B. Then company B is an undertaking of A. As per the, we will take up the data as per the audited balance sheet of the previous financial year, or the undertaking which generates more than 20% of the total income of the company during the preceding financial year. Previous financial year was 1920. So in 1920, if a company B is giving a revenue of more than 20% of the total income of the group is 100, then more. If 21 rupees is being earned by this company, is generated by this company, obviously this company B is an undertaking of A. Substantially the whole of the undertaking means that in a financial year shall mean greater than equals to 20% of the value of the undertaking as per the audited balance sheet of the previous financial year. So previous financial or audited balance sheet, we will check whether this undertaking is having the value of the undertaking. Obviously a company is valued, so value of the undertaking is more than 20%. Then it is more greater than equals to 20%, then it is considered as a substantially the whole of the undertaking. Next power is regarding the investment. Investment in otherwise in trust securities, the amount of compensation received by the company as a result of any merger amalgamation. You know that in merger amalgamation the purchase consideration is being given, right? Whoever is the purchaser will give it to the target company. So here if a company has received some amount due to some merger or amalgamation, then this amount can be it's allowed by the act to invest in trust securities. But the board of directors decided that they don't want to invest that amount in trust securities, they want to invest in some other place. Because other place the investment return is good. Then they will have to take the permission of shareholders by SR first, and then only they can do it. This one is very, very important. Point number C. To borrow money, where the money to be borrowed means that the board of directors now want to borrow some money, right? But the money already borrowed means the previous borrowing is exceeding the aggregate of the paid up share capital, free reserves and securities premium. What does it mean? That suppose paid up capital is 100, securities premium and free reserves are also 100. So 200 is the limit, right? To beyond 200 if the company wants to borrow previous borrowing plus the present one which the company proposed to borrow, then the board of directors first need to take the permission of the shareholders by SR, right? Then only they can do it. But this equation we will deduct the temporary loans which were taken by the company from bankers in the ordinary course of business. Acceptance, here also the banking company is being given the carve out exclusion that you are exempted if you take the public deposit and you also give the loan and borrowing. This shall not be taken as the borrowing money to the banking company. Normal company will comply with the SR and other provisions, banking companies are exempted. What are temporary loans? First, let us discuss that. Temporary loans means the loans which are repayable on demand. The loans which are repayable on demand or within 6 months from the date of the loan, such as the short-term loan. Such as short-term loan, cash credit arrangements, the discounting of bills, and the issue of other short-term loans of a seasonal character. So these are short-term loans repayable on demand or within 6 months from the date of such loan. These are short-term loans. These are called temporary loans, which are excluded from our calculation, right? But does not include loans raised for the purpose of temporary loans. These are the loans, but if you take a loan, if a company takes a loan for the purpose of some financial expenditure of capital nature, remember that word is capital nature, then this will not be considered as a temporary loan. All the capital nature items are always the long term. Okay? To remit or give time for the repayment of or any debt due from a director. If a company's director has taken a loan from the company, he can take it. Some provisions are there governing that also. So here what will be the directors, if your director's payment was due this month, but we are giving him extension, then extension will be given by the shareholders in the SR. If shareholders approve, then only we can give him the extension. Okay. Every SR passed by the company in general meeting shall specify the total amount up to which the money may be borrowed by the board. So, in the general meeting, in the shareholders meeting, the shareholders will specify the amount. Suppose they specify that 15 crore is maximum you can take loan. After that, you cannot take loan. You means the board of directors. So, they have to specify the upper cap. Okay. What is written? That these are the provisions, nothing contained in this subsection 1 and clause A shall not affect. These are the people will not be affected. The title of the buyer or otherwise who buys or takes on lease any property investment on or makes investment or in undertaking as in a good faith. Obviously the outsider who is buying your undertaking or who is taking your undertaking on lease, his title will not be affected if there is some internal irregularity on the part of the company or the board. Fine. So board of directors has to take the previous approval of the shareholders through SR, and SR was not passed. But his title, the outsider's title or the outsider buyer's title will not be affected by this if the buyer is acting in good faith. Fine. Sale or lease of any property of the company when in the ordinary course of business consists of selling or leasing. Suppose a construction or real estate company is selling or leasing any piece of this property in its ordinary courses there, then obviously every time they will not go to the shareholders for taking their permission, right? Through SR. So they are being exempted. Next is any SR passed by the company consenting to the transaction as per this may stipulate the conditions, including the conditions regarding the use, disposal or investment of the share proceeds which may result from the transaction. Fine. So what does this mean? That how to use the sale proceeds can also be directed by the shareholders in the SR. That what and how to use it, how to dispose your undertaking, all the guidelines can be given by the shareholders in the SR, and board of directors have to fulfill it, follow it. Next, provided that this subsection shall not be deemed to authorize. This subsection is specifically dealing or restricting some powers of the board. Powers of the board can be exercised only by the permission, only by taking the previous approval of the shareholders. Fine. But this is a separate topic. Reduction of share capital is a separate topic. So this is dealt under the specific provisions of the companies at some separate sections. So this provisions doesn't mean that the company can reduce the capital of the company by using these methods, that is SR and all. We have to go and check the other provisions which are given under the Companies Act. Fine. No debt incurred by the company in excess of the limit imposed shall be valid or effectual unless the lender proves that he advanced the loan in good faith and without knowledge that the limit imposed by that clause has been exceeded. Here the lender has to prove. Suppose the board has taken borrowing money, so board has taken the money without informing the shareholders or without taking their permission through SR, and they have also not checked that the limits were being breached or not. Limits are obvious, that it should not exceed present plus past borrowing should not exceed the paid up capital, paid up share capital, securities premium and the reserves, free reserves. So that limit is always there. So if it is exceeding, then you have to take the permission of the shareholders by SR, and they have not taken. So lender have to prove. Whoever has given you the money, the third party, has to prove that he had done it his job, he was acting in good faith, he didn't had any knowledge that the limits imposed by this act, this section was exceeded, and there is a non-compliance of this section on the part of the board of directors. He was unaware about it, so he has to prove it. Next we come to these three sections, section 181, section 182 and section 183, one by one. First, section 181. The board of directors can contribute to any charitable trust or other funds. So charitable activities can be conducted by the board of directors on behalf of the company as it is approved by the act, but in few cases the permission need to be taken by the board. Prior permission of the company in the general meeting shall be required when the aggregate amount of contribution in any financial year exceeds the 5% of its average net profits of the 3 immediately preceding financial year. So 3 immediately preceding financial year, the average net profit you have to calculate and then do the 5%. So that is the maximum limit which the board of directors can do in a financial year without taking the prior approval of the members. But if the contribution or if the charitable contribution is exceeding the 5% limit of the aggregate net profit of the preceding 3 financial year, then they have to take the prior approval of the members in the general meeting. Next, section 182. This is a very interesting section, the political contribution. Okay. So first, which are the companies which are eligible to give the political contribution, make the political contribution? Not every company is allowed. Two kinds of companies are not allowed. First one is the government company. Government company is, here it is written the company other than the government company, and a company which has been in existence for less than 3 financial years. So very newly incorporated company and has not completed also the 3 years. Then they are not eligible to make a contribution under this section. Apart from these two kind of company, all the companies are allowed to make a political contribution. Okay, directly or indirectly to any political party. Provided that no such contribution shall be made unless a board resolution authorizing such contribution is passed in the board meeting. And in the board meeting, in the board resolution, you have to justify, the company and the board of directors has to justify why they are giving this money. Okay. Now, few things are also considered as a deemed contribution. First one is under 2A, a donation or the subscription or payment cost to be given by a company on behalf or on account to a person. So, company is giving a donation to a person who the company knows that is carrying out some activity which is likely to support any political party. Then it shall be deemed, if a contribution given by a company to Mr. X and Mr. X is related or engaged in some political activity supporting some party, then that contribution shall be deemed to be a political contribution. Okay, for a political purpose it's been given. Amount of expenditure incurred directly or indirectly by the company on the advertisement. Advertisements, you know that in political, when the parties in the election times, they publish souvenirs, brochures, pamphlets, flags, Many things are there, publicity material actually. So if the company is contributing in the public publicity material also for marketing of the political propaganda of any of the party, then this will be considered as a deemed contribution, political contribution. And where such publication or on its behalf of the political party is given to the political party, this is for the political purpose, this will help any political party, then this is a deemed political contribution. Every company shall disclose in its profit and loss account the total amount contributed by it in this section during the financial year to which the accounts relate. So if you have given a contribution in FY 1920, then FY 1920's account should disclose the amount of political contribution in the profit and loss statement. Notwithstanding anything contained in subsection 1, the contribution under this subsection section shall not be made except by an account payee check drawn on the bank or on the account payee bank draft or any electronic clearing system. So you have to use the banking channel to make a political contribution, right? A company may make a political contribution through any instrument issued pursuant to any scheme notified under any law for the time being in force for the contribution of political party. Here I want to add one thing, very important current issue topic. During the election time, the electoral bonds were also there, right? You can, company or an individual can take a electoral bond, and they were being given on a specific days and specific time was there, window was there through the State Bank of India. So this was there. So if you want, I can also make a specific lecture on the electoral bonds. It's specifically very interesting topic. You will like it. So you can show your interest or communicate your interest to me in the comments section. So I'll read your comments, and if the comments are and people's demand, if there is a lot of people demanding a lecture on an electoral bond, obviously I'll make a lecture on electoral bond as well. Okay. Next one, if a company makes any contribution in contravention of the provisions of this section, what will happen? This is very important. The company shall be punishable with a fine which shall extend to 5 times the amount so contributed. If you have contributed 100 rupees, penalty is 500 rupees. And every officer in default shall be punishable with an imprisonment for a term which may extend to 6 months and with a fine which may extend to 5 times the amount contributed. So company may also pay a penalty of 5 times the amount contributed, and the officer in default will also do it. Officer in default composed of directors and the KMPs. Okay. Political party means any political party which is registered under section 21A of the Representative of People's Act 1921. Section 183. Under section 183, the board can also make a contribution to the National Defence Fund. Board of any company or any person or authority exercising the powers of the board can, or any company in general meeting, may, notwithstanding anything contained in these previous sections 180, 181 and 182, any of the provisions of the Act or any memorandum or association, articles of association or any other instrument may contribute any amount as it thinks fit in the National Defence Fund or any other fund approved by the central government for the purpose of the national defence. Every company shall disclose in this profit and loss statement the total amount or amounts contributed by it in this National Defence Fund or any fund made for national defence during the financial year to which the amount relates. Okay.